Hello friends, today we are going to discuss Article 14, Right to Equality. This is the first article under the heading Right to Equality. I'll read out the law mentioned, the article, and then we will discuss it clause. Like this Article 14 can be subdivided into two clauses. So first of all, I'm reading out. The state shall not deny to any person. So the first expression is the state shall not deny to any person equality before the law or equal protection of laws within the territory of India. So here the key words. Number one, the state shall not deny. So the state shall not deny when the persons are in equal circumstances, equality before the law. So the law must treat everyone equally. And equal protection of laws, this can be interpreted with the help of interpretation given by the American Supreme Court. The Equal Protection Clause signifies affirmative action by the state. Here, the state can make special provisions for socio-economic justice, can make special provisions for certain classes of people, certain groups of people, can make for a particular individual also. That is also allowed. In order to empower, in order to do capacity building, in case two people are not, so two groups of people are not in equal circumstances, one of them is the weaker section, then some special provisions can be made for the weaker section so that the weaker section gets empowered and comes at par with the stronger one. And the day when the parity will be attained, when equality will be achieved, equal treatment will be given to them. This is a matter of common prudence also, that two persons in unequal circumstances cannot be treated equally. And if you are treating unequals as equals, then you are rather doing injustice. The main purpose of Article 14 is to do justice. And therefore, certain questions have arisen. This is a very small paragraph, Article 14, but has plethora of questions. I have written those questions down. First question is, does the article guarantee the right to equality to all persons or only citizens? The language is very much clear. Article 14 says, any person, the state will not deny to any person equality before the law or equal protection of the laws. So denial is not possible to any person, which means Article 14 is not meant for citizens only. It is meant for all the persons living within the Indian territory. And here, persons include citizens, non-citizens. Non-citizens include the immigrants. They can be illegal immigrants also. They can be legal immigrants also. So illegal immigrants are also persons. Now, obviously, illegal immigrants and citizens of India are not held in equal circumstances, and therefore they will not be treated equally. They can't be. Why? Because a citizen and a non-citizen who is an illegal immigrant are held in different circumstances. The differences are very obvious, and therefore equal treatment cannot be given to both of them. So, for example, if a citizen has access to certain social security schemes of the government, like public distribution system, or the citizens have the right to vote, they cannot be extended to the illegal immigrants also. But among all the illegal immigrants who are held in equal circumstances, like A is also an illegal immigrant, B is also an illegal immigrant, and both are in equal circumstances if compared from the point of view of their illegal entry into the territory of India. So at least with respect to their entry into the Indian territory, both are illegal immigrants and hence they are held in equal circumstances. Remember, when we have to compare two people in order to ascertain whether they are in equal circumstances or not, we have to choose some basis on the basis of which, on the ground of which we will compare the circumstances. Right? So, if we compare two groups of people and find that both of them are illegal immigrants, then we can consider them to be equally circumstanced with respect to something. So here, all persons have the right to equality. All the persons, doesn't matter how they came to India. They might have come as illegal immigrants, they might have come as legal immigrants, but they are not citizens. And therefore, all the illegal immigrants stand on the same footing with respect to something on the basis of which we are making a comparison. Let's say, for example, we have to grant citizenship. So we will see all the illegal immigrants. Now, since all of them are illegal immigrants, we have to compare who needs citizenship the most, for whom we can afford granting of citizenship immediately. Why should we deny citizenship to another group? So here we will have to answer these questions. Unless and until we are able to create the differences intelligibly, we will not be able to do the classification. So here, the first question, that whether this article guarantees right to equality to all persons, the answer is yes. All persons, but then they have to claim right to equality on the basis of equality of circumstances. If person A has certain privileges and I am also held in similar circumstances with respect to the privilege given to him. For example, I am also disabled, physical disability. Some other person is also physically disabled. Now he has got certain facilities, certain privileges, but I haven't. That has been denied to me. Now with respect to the privilege that has been granted, I am equally circumstanced. So I should also have that same privilege. If I am not given that privilege, here the state is denying me the right to equality. So comparison has to be done on some basis. Here, the courts have given the doctrine of reasonable classification. For that, we have the test of reasonable classification, which is also called test of intelligible differentia. Means a differentiation based on some basis, some ground which is intelligible, which is rational. So this article has certain underlying principles. So we will see all those underlying principles in a sequence, otherwise we will get confused. Therefore, I have raised some questions. All the questions will not be answered in the same session. So we have divided this session into multiple parts. In part 1, we are going to answer the question that does this article guarantee right to equality to all persons, that we have already discussed. What are the underlying principles of Article 14? This is another question. So, on the basis of the decisions given by the Supreme Court in State of West Bengal versus Anwar Ali case, Chiranjilal Chaudhary case, BP Singhal case, there are so many cases. We will not go into the intricacies of the details of those cases. We will see the underlying principles that have been given to us by the Supreme Court in various cases. The first underlying principle of Article 14 is rule of law, which is correlated with another principle, non-arbitrariness. And non-arbitrariness includes the principles of natural justice. So we will see all these principles, and then we will also see what is the test of reasonable classification and how can we apply the test of reasonable classification to see whether a decision taken by the legislature or by the administration is arbitrary or not arbitrary. If it is a reasonable classification, then it is not arbitrary. If it is unreasonable classification, then it is arbitrary. Article 14 prohibits the government from taking arbitrary decisions. Means every decision must have a reason. There must be a reason. That is why in the judgments also we see in limine decisions are not accepted. If a judge has to give his decision, he has to give reasons as to what led him to come to this conclusion. Similarly, if a government makes a law, there is always a purpose of law, an objective that the government must explain. What is the objective of the law? Why the law has been made? Only then we can see a reason. In fact, reason has to be seen in almost every decision. Be it a law, be it an executive decision, it's an administrative action. Reason has to be there. Let's say, for example, we have seen in the Constitution, I'm just giving you an example here, that governor holds his position during the pleasure of the president. This is written in the Constitution. But the same Constitution has written Article 14 also. Now, if the governor is removed without giving any reason, simple removal, without any reason, the Supreme Court in BP Singhal case has held that this is not done. This is unfair. Even if the president is not bound to give a reason to the governor as to why he is being removed, there must be a reason. In Article 111, we see that the president, in case of an ordinary bill, has pocket veto. Though it should not be called pocket veto, but here, in order to understand that, let's see what is pocket veto. The expression there in Article 111 is as soon as possible. So the president will give assent to an ordinary bill as soon as possible, or to a money bill also. If a money bill also comes to the president, he will take time. How much time? The deadline has not been given. We will discuss Article 111 later. Here I am just using as an example. Now, no deadline has been prescribed. Even then, if the president takes a long time without any reason, though nobody is going to ask him the reason, he is not supposed to give reason, but he should have reason. If he takes inordinate time, right, if he does inordinate delay and does not give a reason as to why he delayed it, then this is an unconstitutional act on his part, because he has acted arbitrarily. As if it's my will. Whenever I want, I will sign it. No, he cannot do that. Why? Because decisions must be non-arbitrary. So Article 14 contains this principle also, the principle of non-arbitrariness. Why? Because there is rule of law. In rule of law, it's the written code that works, or even the convention or customary law can be there. But there has to be a prevalent law which rules. Man doesn't rule. Individual doesn't rule. Because if individual is given free will, he will take arbitrary decisions as per his will, as per his conscience. This will lead to anarchy. So if we don't want anarchy, we want rule of law. Therefore, arbitrary decisions are strictly prohibited by the Constitution of India. And Article 14 contains this principle. This is the underlying principle of equality. There can't be equality if there is arbitrariness, if there is no rule of law, if there is no principle of natural justice. One of the principles of natural justice is audi alteram partem. That is, every person has the right to be heard. When he is accused of something, when he is accused of some offense, let's say, he must be heard first of all. If he is not heard, then a unilateral decision will be given without having heard him, which is arbitrary. So here there is arbitrariness. Our Constitution also gives the right to every prisoner, to every arrested person, to consult a lawyer. Why? He must be represented in the court. He has the right to be heard. If he is not heard, then an arbitrary decision will be taken. So we have just now seen the underlying principles of Article 14 are: 1. Rule of law. Correlated with it, principle of non-arbitrariness. So decisions must be non-arbitrary, which includes the principle of natural justice also. Now, let us see what is the test of reasonable classification. This is a very important test which we will use to judge every administrative action, every legislative action, in order to see whether that action is arbitrary or non-arbitrary. If it is not arbitrary, then there is no defect in that law. It's a good law and it won't be struck down by the Supreme Court. But for this, we will have to wait for the next part of the same video. In that, we will see what is test of reasonable classification, and we will see case studies. Case studies in which the test of reasonable classification can be applied, and we will examine certain activities, certain actions of the government. We will see whether they had been held arbitrary or not by the Supreme Court of India.